Hi, and welcome to Is That Even Constitutional? A podcast that looks at the Constitution through the lens of public events. On July 8th, the Supreme Court lifted a district court order which has stopped the Trump administration from firing thousands of federal workers. Some people think this is the end of litigation over these federal firings, but in fact, it's really just the beginning of federal litigation. Now, it's hard to keep track of how many federal employees have been fired under the Trump administration. It all started with the Department of Government Efficiency, which helped or directed the firing of thousands of probationary employees. Now, these firings have been litigated, and many of these probationary employees have been, in fact, reinstituted in their jobs at agencies, but many have then been refired because of other litigation. Now we've moved into another layer of firings, and these are called reductions in force. Now, reductions in force are not firings of individuals, but they're actually job eliminations at particular agencies. And these are done under a totally different legal regime, and these are also something that can be challenged in court. So what was the Supreme Court case about? Well, this was a decision that involved thousands of federal reductions in force or RIFs across many, many different federal agencies. Now, this case was based on an executive order that President Trump issued in February of this year, and it is essentially an argument that this executive order was illegal. Now, why? How could an executive order be illegal? Well, the argument is that the executive order essentially told all federal agencies to reduce the number of employees that were at these agencies. Now, this would be a problem because reductions in force can only be done if there are surplus workers at an agency. And a blanket order saying that all agencies had surplus workers without an actual establishment of that fact would seem to be a violation of that requirement. So the lower court in this case, a district court, gave a number of examples of RIFs that were at agencies that clearly didn't have surplus agents. So for instance, they gave the example of a child care center in Santa Clara that had to shut down because the local federal Head Start office was closed, and so they couldn't provide the grant that would normally be provided to this child care center to keep it open. There's an example in Vermont of a Department of Agriculture office that didn't have enough inspectors to go out to inspect damage to fields, so that money for field damage couldn't be provided in time to farmers who needed it in order to plant for the planting season upcoming. Another example is Social Security Administration that fired so many people that their website was not functioning. People couldn't get through on the phones, and it was very difficult for people to get meetings to work out how to get their benefits. So why did the Supreme Court strike down the district court, which essentially put a pause on all of these firings? Well, the Supreme Court essentially said that the district court did not have all those examples I just cited before it. What the district court held was that the executive order itself, which directed agencies to come up with all these different RIF plans, was a violation of law because it directed agencies who did not have surplus workers to do these firings. But as the Supreme Court pointed out, and as we've discussed in previous podcasts, executive orders do not have legal effect by themselves. President Trump does not fire individual workers. Firings are done at the agency level. So the real holding of the Supreme Court is that the executive order was not what the plaintiffs have to challenge. Plaintiffs have to challenge individual RIF programs done at each agency. So the issue here is really timing and resources. In the particular Supreme Court case, a whole coalition of states, local entities, et cetera, were all able to bring one large case to stop all of the various RIFs across the federal government. Now going forward, individual RIFs are going to have to be brought or challenged by employees at the agencies or by people who are going to be affected. So, for instance, if an employee is RIFed or fired, then they could bring an argument that, or bring a challenge that their particular agency doesn't have surplus workers and consequently really needs to have that position kept. Or if a citizen outside of the government is adversely affected by a RIF, then they'll have to make an argument that those RIFs were not authorized. So, for instance, say that somebody who's affected by the floods in Texas can say that RIFs were responsible for harm done because there were there's not sufficient warning, or there were not people available to help them during the flooding. Then they could argue that the RIFs were in violation of the requirement that there be surplus workers. But again, this would all have to be done in a very particular manner. Now, it is the case that there have been particular cases brought against particular RIFs that have been successful. So, for instance, a court stopped the dismantling of the AmeriCorps program. That's a program that hires individuals to do essentially to do work at the individual level to help communities with either poverty programs or with civil safety programs, something akin almost to a domestic Peace Corps. And there's a lot of money associated with it and a lot of workers. And the Trump administration tried to dismantle it, and a lower court said that those RIFs were illegal because the proper administrative procedures had not been followed in order to do those RIFs. Layoffs at the Department of Education were pretty much halted because the Office for Civil Rights was essentially stripped of enough people to follow up on civil rights complaints. And the civil rights requirements are that civil rights complaints be expeditiously investigated, and the complaints could not be investigated in any manner because so many people had been fired, and so the Department of Education layoffs were limited. So despite the Supreme Court case, the litigation is not over. However, the litigation is going to have to be piecemeal. It's going to be more difficult, and really the end result is very unclear. And so that is where we are now with the litigation over the RIFs. The Supreme Court case is significant, but it is not the end of the litigation. So stay tuned for more details and more podcasts going forward. Thank you.